Hello, everyone. I'm Amanda Empey, and this is my colleague, John Belo, and we are labor and employment attorneys at Bodman PLC. And today we're here to talk about a question pressing on many of our minds. When is a worker an employee? And when is a worker an independent contractor? Now, John and I could talk for hours on just this question alone, but today we'll scratch the surface. We'll give you an overview of the different areas where this determination can expose employers to liability, explain the applicable tests that are used by many governmental agencies, and provide some best practices for your workplace.
Okay, thank you. Thanks, Amanda. Happy to be here. Maybe just a touch more. I've been a litigator for, I guess, going on 31 years. And have litigated the question of independent contractor on a number of fronts, including in the area of worker compensation and the definition of an independent contractor versus an employee for purposes of premium charges and liability with respect to workers' comp. And so that, I think we go to the next slide, don't we?
Yep. There we go.
Okay, so I think for purposes of today's exercise, we need to remember that this is, well, not something you're interested in. It is a topic that people could talk about for hours. And the reason for that is that there are differing standards with respect to different laws and regulations. And that I think that the goal for us today, besides what we've so neatly written on this slide card, is to point ourselves in the right direction, as well as get some solid ideas about what best practices are in order to do the very best you can with a topic that is, here's a lawyer saying this, it's just not black and white. And this is truly the definition of an area that is not quite black and white. Yes, there are some sort of slam dunk, black and white, bright line circumstances that will tell you that someone is an employee versus an independent contractor. But like life, most of our businesses are experiencing or dealing with or want to have somebody that's a little more in between. And so we're going to be aiming at trying to do the very best we can to address those that are probably somewhere in between the bright lines in order to try to keep businesses, the valued members of the chamber and in the business community, out of hot water with the Department of Labor, the National Labor Relations Board, plaintiff law firms, and, worker comp carriers, as well as the Michigan Unemployment Insurance Agency. So we're going to try to aim at best practices and risk avoidance, and that's our goal. So what is the big deal? Well, the big deal is that if you have one or more individuals working in your business, whether they're more on a lower level or higher level, any number of issues can become a problem to the extent you misclassify someone as an independent contractor versus employee, or I suppose vice versa. Fair Labor Standards Act, which is actually something that Wendy touched on right in the beginning, is looking at whether or not someone, if they were more properly classified as an employee, would be or potentially would be entitled to overtime, possibly even minimum wage, although that doesn't come up very often. There are tax issues as well, because with employees, we have standard withholding, we have Medicare, etc. I-9 violations with independent contractors. Many companies are not making sure that the I-9s or E-Verifies are such that they're protected with respect to, or the individual is protected from an I-9 standpoint. Like putting it all on the employee and saying that, I have no responsibility. Sometimes that can be a problem. There can be problems with your carriers with respect to excluding people from employee benefits. We're not going to really talk about that much. There are also Affordable Care Act or Obamacare Act issues. That's another topic that could get its own webinar. Today, we're not going to really do ACA issues. There's National Labor Relation violations. I mentioned that earlier. There can be union issues with respect to people collectively discussing wages and hours and conditions of employment and so forth. Not to mention the good old-fashioned FMLA, ADA, and paid sick leave. Right? With independent contractors, we don't go into any of that with those folks. At least many businesses don't. And that can be a problem if the person at issue is really more an employee. Next slide.
Thanks, John. And as John mentioned, there's a lot of action surrounding FLSA violations in the independent contractor world. For those of you who don't know, the FLSA, or the Fair Labor Standards Act, is the federal law which governs minimum wage and overtime requirements for employees. Of course, the FLSA's requirements do not apply to workers who are properly classified as independent contractors. But if a worker is improperly classified as an independent contractor, the employer can be on the hook for any violations of the FLSA that occurred during that period of misclassification. And generally, this will look like back pay of overtime wages. As John mentioned, it's pretty uncommon that the minimum wage piece comes into play, but you never know. And it's important to remember, though, that if you've classified someone as an independent contractor, you're typically not tracking their hours worked. So if an employee says they're working 70 hours a week and they're really only working, 40 or 50, courts and the Department of Labor will tend to take the employee's version of events as true because you don't have any documentation to prove otherwise. So that back pay and, what the alleged back pay can add up really quickly, especially if you've misclassified a group of employees all at once. Now, employers can be held liable under the FLSA in one of two ways. First, an individual worker can sue, and they can also initiate what's called collective actions. In other words, they've brought a lawsuit on behalf of themselves and others who are similarly situated, i.e. their fellow coworkers. These collective actions are on the rise, and they're very costly to employers. And it's important to note that there's no defense for, we thought we were doing it right. These are all technical violations, and if you're found to have violated the FLSA, you'll be responsible for the plaintiff's damages, liquidated damages, and the plaintiff's legal fees and costs.
Hey, Amanda, let's just add here that, because we're actually litigating these right now, that in a case that we have within the collective of employee plaintiffs is a discrete group of people that worked for a temporary staffing agency.
Mm-hmm.
And well, we might all say, or some of us might say, well, what the heck, right? That person is an employee of the staffing agency. Well, not necessarily. They actually might be an employee of the staffing agency, but for purposes of the Fair Labor Standards Act, easy for me to say, they're also an employee of the company that has the master service agreement with the staffing company. So they're our baby. They're our employees, even though they come from another contractor. So
Right.
Just wanted to add that.
Yeah, you're absolutely right. And it gets so messy so quickly. And especially the larger the employer, the more, misclassifications that occur and the more these, cases just snowball. Which leads me to the second way that an employer can be held liable under the FLSA, which is through the Department of Labor. The Department of Labor has the authority to audit employers. So DOL can show up at your door and request to see your payroll and timekeeping records for the past 2 to 3 years, depending on whether they think the violation was willful or not. And they'll expect you to produce documents relatively quickly. The FLSA has certain record keeping requirements. So, once they start, asking for this stuff, it doesn't take long for it to get messy really quickly. And it's also to note that once the DOL arrives on your doorstep, they aren't going to limit the search to the issue that flagged their attention. They're going to look for misclassification of non-exempt employees, regular rate issues, time rounding issues, etc. So it's important to get this right in the first instance, because the DOL has entered the 21st century. That they're not sorting through boxes of paperwork anymore. They have all this information at the tip of their fingertips. They can print a report that has your organization's 1099 payments and target those individuals strongly, especially in areas where they know that, industries that use independent contractors relatively heavily. Again, it's important to perform your own audit and to make sure you're doing things right before the DOL shows up. So, which brings us to the question, how do we do it right? How do we classify workers under the FLSA? The DOL recently enacted a new economic realities test rule. It went into effect last month, and the factors that the DOL looks at are on the screen. But you don't need to memorize them. The test is what it sounds like. Is the worker economically dependent on the employer for work? Does the worker actually have skin in the game? If the company were to cancel its contract with that independent contractor, would that independent contractor effectively be unemployed because they don't have a business outside of that one contract with the particular company? This is what we're looking at here when we talk about, are they in reality actually economically dependent on you, the company that's hired them? And as for how that's different from what we've done in the past, the DOL used to prioritize two core factors. And now the factors are not weighted, which means that the worker is more likely to be classified as an employee just because, they're not going to prioritize the nature and degree of the control or the worker's opportunity for profit and loss.
Right.
And so, as I said, it went into effect last month, and it's facing multiple legal challenges, both by employers and by workers. We should all keep an eye on these issues for any new developments, but as of right now, the new rule is in effect.
Okay. Is this me?
If you want to take it away, go for it.
Yeah, sorry. I was just noticing my hair's a little out of place. Yeah, I mean, look, these, as we see, we can even see on the news sometimes, many of what might be viewed, and I take no position at the moment, but what might be viewed as more progressive definitions used by the National Labor Relations Board or the Department of Labor are being challenged on multiple fronts. The most bright line challenge is that on March 6th, there was a resolution to overturn the new rule. It is pending. If it were to pass, the new rule would not be enforced, irrespective of the lawsuits that are pending, challenging its application. So that's that. Let's, yeah, go ahead.
Oh, well, it is as it says on the screen. So we've gone over the several challenges and, we'll all keep an eye out. But for now, this new rule is in effect and we should all be acting as though it's in effect and being aware of the possible consequences for violating this test.
Right. And I'm going to raise something that might seem a little bit controversial, but, one of the reasons that we try to aim to do the best we can is that sometimes that works if the DOL comes in. They will take almost for face value what you've done. And what do I mean by that? The DOL is is overborne with work right now. And they're really having a difficult enforcing all these new rules and conducting audits in any efficient or effective way. And they can't get people to work for them either. So when we try to offer best practices to hedge against the risk, they can work, even though they may not be as bright line as some of these rules would seem to mandate. Hope that makes sense. So the economic realities test of the Department of Labor is in effect now until changed.
Yep.
The next issue is tax audits. This is a real simple one. If you have a 1099 employee, which many of our clients call these folks, and you're not doing the customary withholding and taxes, you open yourself up for potential issues if those individuals are not paying their taxes the way they should. Now, you could say ideally, somebody that's working for you as a 1099 independent contractor, well, they are paying their own taxes and you won't hear anything else about it. And I got to think that probably is true in most cases. However, should they play fast and loose with their taxes, like I would like to do, but I don't. The company could be on the hook for, the withholding, the fiduciary tax and so forth. That's a bad situation. The other issue is the unemployment agency in the state of Michigan. Their new thing, or relatively new thing, is to sue to have all independent contractors be deemed employees, thus creating a huge gap in what companies have paid under their standard rate for unemployment insurance benefits. And so that's another area where, the independent contractor versus the employee is under attack. And so, we want to start tightening up those relationships to avoid that. I think we can go to the next one. On the issue of taxes, the IRS is looking at what they call a common law independent contractor test. It looks at three basic areas. One of the things, instead of wasting our time and me reading this to you, you should look at the type of the relationship area as being important, because I can't stress enough that the language of a contract, or having a contract itself, is so critical. So it looks like we have some questions here, and it may be before we jump ahead too much. Olivia asked, what is the specific new rule change? Amanda, do you want to just quickly go back up to the change and what it means by changing the weighting of the factors?
Absolutely. So on the screen is the factors that the DOL will look at when they are making this determination, whether you've properly classified an employee or not. So this is the opportunity for worker profit or loss, depending on managerial skill. It's the investments by the worker and the potential employer, the degree of permanence in the work relationship, the nature and the degree of control, and the extent to which the work performed is an integral part of the potential employer's business and skill and initiative. Now, this all sounds like, pretty legalese, but in effect, they're looking at things like, does the worker have an investment? Are they their own company that's coming in and performing a service that the company doesn't otherwise typically perform? Or are they, coming in and they're really doing the type of work that this company generally does? That's a core element of their business. Do they come in and they bring their own tools? Do they look at their own time? These are the types of, real factors that the DOL is looking at. And as to what's changed, previously, the DOL used to highly prioritize these two factors on the screens, the nature and degree of control and the worker's opportunity for profit and loss. And so what's changed here is that no longer are these the two guiding principles. They're not the light post at the end of the street. They're really going to look at all of the factors right here, which means that it's more likely that they're going to decide that a worker should be classified as an employee and not an independent contractor.
Thanks. We have one other question I'll try to hit. Tracy asked, at a school, we have non-employees through EduStaff that are here full time, so they would be our employees. Okay, so the agreement with EduStaff is going to determine everything between your school or business and EduStaff. Obviously, I don't have the ability to look at that service agreement. So many times they're called master services agreement. But many times in the ones that I do, they have, in using just the names you've given, they would have EduStaff indemnifying the school for any and all issues relative to wage and hour, worker classification, et cetera, et cetera. Ultimately, though, the risk is there to be viewed as a dual employer, such that either you and or EduStaff would be responsible for any wage violations and other things. But again, those types of staffing agreements will contractually address these issues irrespective of the statutory requirements. So in your example, EduStaff would be responsible for adhering to all of these rules, and to the extent that your company or school would be responsible under any agency action, they would indemnify you. But again, that's the result of good contracts. I hope that helped. We're getting a lot of questions coming through. We're not going to be able to hit all of them, at least right
And I
now.
will say, oh, sorry to interrupt, John. We are going to be going through several scenarios, which might highlight some of the specific, different types of factual scenarios that this might come up. But again, these are all really fact-intensive analyses depending on the industry, the employer, and your relationship with your employees. So if there's any doubt in your mind, we encourage you to seek legal advice on these issues to hedge off these costs. Is this where we left off, John?
Yep. Right.
Or is he here? If you feel good on this slide, I can go to the next one.
Yeah, absolutely. I think it's time to go look at this crazy 20-point test.
Love a 20-point test. So on the screen is the 20-factor test that was used by the IRS for many years. It has 20 factors, hence the name. And these 20 factors range from, the type of instructions you give a worker, to whether they use their own tools, to whether they provide their own benefits. But in 2019, the IRS replaced this test with a common law test that John just went over. But Michigan still uses this test in the workers' compensation and unemployment insurance arenas. And this is an area where these misclassifications tend to show up first, because a worker might file for unemployment and then the UIA says, oh, look, we don't have you listed here. You're not an employee. And the employee goes, no, I worked at company X for 3 years. This prompts these agencies to look into the classifications of not only the individual employee who brought their complaint, but all employees or workers in this organization. And that's where they're going to look at that printout of W-9s I mentioned earlier and, name, okay, Bob and Joe, they paid 1099 payments. Are they properly classified? And so what do these audits typically include? They're going to look at your financial books and records for the past 3 to 6 years. And upon completion of the audit, you'll be required to pay any outstanding taxes deemed owed by the auditor, and possibly penalties as well. As John mentioned, this is a huge area of interest for federal and state governments. Simply put, they want your tax dollars, and these audits are a way for them to collect on unemployment taxes. Industries that use independent contractors are very susceptible to these audits, because the agencies are likely to know that they're going to be able to find some misclassification, especially with these changing rules, and therefore find untapped tax dollars. And again, it's important to realize that these agencies talk to one another and they share data. So if you're targeted by one agency, you're likely to have problems in all areas.
Okay. Workers' compensation. I actually had the benefit of litigating a couple of these cases in the past. So workers' comp, you know, your carrier comes in because you have to have it. They look at your payroll as a means of determining your premium and your coverage. And then at the end of the year, they come in and they take a look at your payroll as well as other financial information. And they do an audit and they try to reconcile whether or not you've paid enough premium, because under the Comp Act, you know, the coverage claims can be outside of the coverage period. What does that mean? Well, if you have 10 office workers and 50 people in the field, and all the people in the field are 1099s, and they come in and say, hey, you only paid premium on 10 people, but you should have paid premium on 60, then you owe us, you know, $200,000. And, you know, obviously that can be a problem. Now, I've exaggerated a bit, but just to make an example. Now, the comp rules regarding a legitimate independent contractor and whether or not they need to be covered under your comp coverage. We're not trying to capture the plumber that comes into your business, or, you know, the electrician, in order to make your infrastructure or your physical plant better. We're talking about people, companies using independent contractors to do the parts of their core business, and whether or not they are legitimate. You know, somebody asked in the comments, does it matter whether a person's incorporated or an LLC? Excellent question. For purposes of all of these tests, 1099 employees, they should make their own LLC. Run out, there's hardly any cost, and incorporate yourself. Why? Because a lot of times people, the various agencies that come in and they see that something is with an LLC, they don't even lift the next rock. You know what I mean? They don't necessarily want to look under every rock, but that is a strategy. That is one of the bona fides of an independent contractor relationship, is that party is, you know, operating it as an LLC or a C or an S corp, I guess, depending on what they want to do for their own taxes. Not a partnership, by the way. Okay, where are we? Independent contractors.
You know, John, if you don't mind me interrupting, we got a really relevant question in the chat here that just noted what we've been emphasizing all along, that different systems, different agencies all have different tests. And the question was, from a practical standpoint, what is a business to do? And the solution is that you should really be applying the strictest standard to all your employees to ensure compliance. You know, we're highlighting that, you know, they might be determined an independent contractor under the FLSA, but they might not under like the NLRB. But from a practical standpoint, applying the most stringent test is the most prudent way forward to ensure compliance with all of these agencies.
Yeah, I mean, I have a list of things that we'll talk about just a little bit later in the best practices slide, that I think will go a long way toward trying to answer that question, because yes, it is a bit wild in what we're trying to deal with. So the question is, with respect to all of the laws and regulations, you know, what's a company to do to make itself, I guess, bulletproof? That's not happening. There's no guarantees, because it's just too unwieldy right now. But what are the best practices? And we'll jump on that just a little bit later, like in the totality.
Big picture.
Yep. Well, and how do you address each of these when they have different standards? I totally get it, right?
Yep.
It's like they don't want us to do business, right, guys? But there are some strategies, and we are going to talk about them.
Yep. Are you all set with this slide, John?
I am, thanks.
Yep.
What number is this? Oh, yes. This is something that has actually, I think the chamber has reported on it and asked for people to contact their representatives and so forth. But the Michigan legislature has introduced bills that would copy California's what they call the ABC test. ABC test has 3 components, and it starts with the presumption that everybody is an employee. Okay, so the burden is on the employer to show that somebody is not an employee, but is a legitimate or authentic independent contractor under the ABC test. The ABC test is very difficult to beat if you're trying to establish independent contractor status. The first part of the test, control and direction, that's not too hard. That one, the next one though, the next component I think is the most difficult. And that is that if the individual performs work outside the usual course of the payer's business. Okay, so if a 1099 employee or a 1099 contractor does any part of your core business, they would be defined as an employee. In other words, anyone other than the electrician that comes into work on your office space because half of the lights are out are probably going to be defined as an employee under the ABC test. Now, this test has not been adopted yet. It's very controversial because, let's face it, if many companies have people doing parts of their core business as independent contractors. So that's going to be a difficult test to overcome should it become the law. It is not the law right now. Let's go to the next one.
And here we've got yet another area that could expose you to liability, any I-9 violations, which the Department of Homeland Security requires employers to complete Form I-9 each time that they hire anyone to verify that that person is authorized to work in the United States. And of course, just like all the other employment requirements, this does not apply to independent contractors. But if the Department of Homeland Security finds out you've misclassified someone as an independent contractor, then the employer may face civil penalties. And the fines vary depending on the size of the business, the evidence of good faith, or the seriousness of the violation, and of course, whether the individual was actually an unauthorized non-citizen. But it's, just another area where we should be watching and preventing our organizations from facing liability. And of course, they have their own test. What else? They look at the factors that are on the screen here when making this determination. And in this instance, no one factor is given more weight to the others. They just take a general look. But the principles are largely the same as we previously discussed. It focuses on control, the economic realities, and really whether this independent contractor is a part of your business and run in its typical fashion.
Okay. The NLRB again, in 2023, I think it's March 11, was it? March 6, maybe? Reverted back to an independent business analysis. Again, this is cutting toward the direction, again, of whether or not people are legitimately operating their own business and just giving part of their time to the alleged employer. And the first component, does the worker have a realistic ability to work for other companies? Okay, so if somebody is working for you as a 1099 independent contractor, 40 to 50 hours a week, the NLRB is going to look at that and say, hey, this person doesn't have an opportunity. Now, I realize your contract said that he or she can work anywhere else but this is, this is not realistic. Okay. Does the worker have a proprietary or ownership interest in their work? That's a tough one. I would think anytime you invoice for your services, you do have an ownership interest in your work. So that's maybe not too tough. Does the worker have control over their own business decisions? That's another one. I'll talk about how, from a strategy standpoint, we would want to identify our 1099s in really good independent contractor agreements as a strategy toward avoiding the risks, including with the NLRB. Let's go to the next one.
And so we've covered a lot. The chat definitely seems like it's blowing up with a lot of specific factual questions, and hopefully these scenarios will help answer some of those. Here we've got Mac, who works as a plumber for Tony's Market. Tony calls Mac when there's a plumbing issue at the market, and Mac issues Tony an invoice after he completes each project. Now, Mac uses his own tools and sources the parts necessary to fix Tony's plumbing, and the cost of which is included on the invoice to Tony. Mac maintains a website advertising his services to the public, and he frequently provides his services to other businesses and individuals. Is Mac an independent contractor or employee? Feel free to, shout out your.
I don't know, does Wendy or Becky want to jump in and maybe have relay an answer by anyone or answer and comment?
That's a great idea, John. We'll give you all a minute.
Try to see if we can make it a little more interactive. I don't know if that is too clunky or what, but.
Yeah, if we want to use the chat box for that, that's probably the best way for us to monitor on our end.
Okay, looks like we have some chats coming in. Looks like all of the answers are, I call them ICs, independent contractor. Amanda, what would you say about this example? We were thinking that this is as close to our bright line as we could get with.
Yep. This is an example of what, we would say is most likely an independent contractor. Well, you never know what some of these agencies are going to do. Importantly here, Mac's providing a service that Tony's Market doesn't provide its own customers. Mac's coming in on discrete projects where he's issuing an invoice, he's bringing his own tools. Tony doesn't know anything about plumbing. Tony is directing Mac to just, hey, I've got a problem, can you fix it? But he has no control over the level that Mac is gonna, or the type of work Mac is gonna do, or the methodologies by which he might do that. So, and importantly, Mac is also advertising his services to other people. He has other clients. He's not economically dependent, to use the DOL's language, on Tony. So in this instance, it would most likely be an independent contractor.
Right. That was an easy one.
They only get harder from here.
Right. Here's Becky. She works with Numbers R Us. They agree that Becky is an independent contractor. They sign a contractor agreement. Sorry, Betty is paid as a 1099. She comes to work when Numbers R Us tells her. Sometimes she works a little, sometimes she works more. She uses their equipment, collaborates with their employers. She pushes out work that Numbers R Us provides as their core services, although that's not quite said there. She's paid hourly. And she receives a biweekly paycheck along with the other employees of Numbers R Us. And she works on various projects, and she has done so for 3 years. Would we be more likely to classify Betty as an employee or an independent contractor?
It looks like the chamber was able to create a little poll. So please do submit your responses, and then John and I will go over the answer.
Yeah, so everyone's doing great on this. Hopefully these weren't too easy, but the first scenario, I should say, is the most bulletproof one we have. Betty is very much likely to be classified as an employee under all of the relevant tests.
Oh, and you all did so great. 94% said an employee.
Right. ABC test, she's doing core work. You know, NLRB test, 20-factor test, common law independent contractor test. She's going to be viewed as an employee and have all of the ramifications of that. Let's go to the next one. We will have some Q&A at the end, and I see some Q&A in here, like from Olivia and Stacy, that we'll go back to at the Q&A session. So we will not leave these unanswered. Just telling you.
Here we have Stacy, who works as a truck driver for Giant Warehouse Corp. Stacy has her own LLC through which she owns and maintains her own truck. Stacy chooses which deliveries she does, but for the past 5 years, she's only done deliveries for Giant Warehouse. She gets healthcare, dental, and vision through Giant Warehouse. Is Stacy an independent contractor or an employee? Well, here, even though Stacy has her own LLC, in that instance, it doesn't mean it's bulletproof. Here, under the economic realities test, Stacy is going to be classified as an employee because has only done deliveries for Giant Warehouse. So if Giant Warehouse cancels, the contract with Stacy, then she's effectively unemployed. She has been dependent on them for the past 5 years. So it's important to note that, while John's advice and while our advice is to give you best practices like setting up, corporate entities, it's not a bulletproof plan. These are all highly factual, fact intensive analyses that really go to the heart of the test that we've talked about before.
Right. But I do think that Stacy having her own LLC does go a long way toward the idea of the independent contractor status. It's just that the rest of the facts, albeit not too many here, kind of blow that out of the water. Particularly her receiving group health and dental through Giant Warehouse. Which one are we on now? 4?
Yep.
Yeah, Cameron. Cameron's a pilot for Flyboys, provides jet services. Flyboys only calls Cameron when they're short-staffed. When he's on duty, Cameron flies Flyboy jets to their client-specific trips lasting weeks at a time. The rest of the year, Cameron operates his own private plane company, providing clients with quick trips from Detroit to Traverse City. Is Cameron an independent contractor or an employee?
I'm interested to see everyone's responses. Do you want to hold off? Felt like we were trying to be tricky with this one.
Yeah, this is actually a pretty tricky one.
Yeah. Us lawyers love a trick question.
Am I allowed to say I don't know?
All right, we've got 84% saying that it's an independent contractor and 16% saying that he's an employee. John, you want to take this one?
Yeah, that's fair. Actually, I'm going to let you make a comment first.
Okay. Well, as we said, definitely tricky. I think if we didn't have that first bullet point that said that Flyboys, only hires Cameron a few times a year, that it would be probably an independent, probably an employee, because he's flying the jets to their specifications, he's using their jets. These are all things that typically look like an employee. But here, he only does it a few times a year, and he owned his own other business, but providing those quick trips. So if Flyboys canceled their contract and never called Cameron again, he would be fine. He's not economically dependent on Flyboys. But it's definitely a messy situation for sure. I think depending on the test, depending on the agency interpreting, these facts, it could really cut either way.
Right. And I think what's just as important is what's missing here. You know, does Cameron provide his services to Flyboys as an LLC, that being the same LLC that does the quick trips from Detroit to Traverse City? You know, what does their contract say? Things like that. So we're missing some things, but on balance, I think our group is probably right. It's still more an independent as opposed to an employee. Somebody put in the comments that it's a temporary employee. I mean, his services are temporary. So that is also a possibility as opposed to an independent contractor. All right, next one. Best practices.
Yep. So as we mentioned, you know, it's hard to create a bulletproof plan. But here we've got some best practices for you to take with you today to try to, you know, protect yourself from liability. First, identify and review current independent contractor relationships. Take, you know, that fact-intensive look that we did with our scenarios and really examine, you know, the heart of the relationship there. And you can go ahead and communicate and collaborate with your workers. Oftentimes, as we know, the workers want to be classified as independent employees as well for, you know, their tax benefits or whatever it may be. So encourage those independent contractors to set up their corporate entities, encourage them to make their businesses look more like the independent contractors that they desire to be. In doing that, you should update your written agreements and make sure that, you know, they're not providing services just to you or just to someone else, because then that creates that economic dependence that we've talked about throughout. And finally, this is a minefield. Feel free to contact legal counsel with any questions. We're more than happy to help. And finally, stay informed. I mean, I think if this presentation highlighted anything, it was that the law is changing on this all the time. There's, you know, challenges to the rule changes. It's a lot to take in. So keep your ear to the ground and stay informed.
Yeah, and I think I'm gonna say some things about what I believe are the best things to address both in a contract as well as, and they bleed into practice, because I'm assuming that if you make a contract that says we're going to do A, B, and C, and you're going to do A, B, and C, that in practice, they would be one and the same. I realize sometimes they're not. But I think that best practices dictates that there should be a really good independent contractor agreement that specifically describes the services that the contractor is going to provide, that the contractor have his or her own business that is an LLC or C Corp or S Corp, I suppose. You know, statements about who's responsible for the ways and means of the services, as well as who is responsible for outcomes. A description of both the amount and the method and mode of payment. I like to see monthly invoicing for services and then payments made net 30 upon receipt of an invoice. There should be an explanation about expenses. There should be a statement that the person is responsible for all their own insurance coverages. It should say something about the contractor getting all of their own licenses to the extent that you need a license for the type of service that you're dealing with. There should also be terms about terminating. You know, is this a 1-year agreement? Is it month to month? Is it whatever? There should also be something about ownership of copyright and intellectual property in there, so that you protect yourself that way. There also can be non-compete terms in there or non-solicitation terms. But again, the whole point, and also the written agreement as stated on this sheet here should say that the independent contractor is not exclusive to the principal hiring them. Now, that's going to be a tough one because a lot of our 1099 workers, they only work for their one principal. So I realize that that presents a challenge, but if you build appropriate agreements and you hit the edges in a way that we have recommended, you will do the best you can, which is where I started in this, or we started in this presentation, which is under the economic realities, what is the best we can do? How are we pointing in the right direction? And the things I just mentioned certainly go toward achieving proper independent contractor status. So we've got a couple minutes here, I think. Wendy, do we have time?
We do. Yep.
Okay. There's Amanda, do you want me to grab a couple of these?
Yeah, you go for it.
Not too many here, but Stacy B, we have a land person who's an independent contractor. No other land person subcontracted or employed. So that means that this person doesn't employ others underneath him or her. We receive an invoice from this individual. They have their own computer. We send 1099. The individual does title work and research throughout Michigan for our companies. How can we determine if he or she falls into the requirements to be an employee? Well, I would start with having a proper independent contractor agreement with some of the elements that I just mentioned. We've really kind of covered that, but your land person doing piecemeal work, certainly that is an element of independent contractor status, as opposed to, someone who is doing full time. All right, you want to take one?
Yeah, I'll take the most recent one here. We've got, does it put a company at risk if they have someone in question as an employee, or if they have some trainers as an employee and some as an independent contractor? And here, I think that gets to the, there's not a lot of detail in that, but it gets to the idea of it's a highly fact-intensive analysis. In this instance, if an employee is performing the same task as an independent contractor, it's important to, distinguish why that other worker you're classifying them as an independent contractor. Do they offer their services to someone else? Are their, services, are they really the same? Or, when do you call them in? You can have employees that are contingent employees that you just don't call in on, 40 hours a week. In these instances, it's important to really take a firm look at what's actually happening there, and to realize that if they look identical in every other way and you've just paid them via 1099 and you have an independent contractor agreement, but it's a form agreement, that you might not be protected in that way.
Right. And there's another question here about someone wearing uniforms, having the same equipment and so forth. Independent contractors ideally are providing their own equipment to conduct the ways and means of their work. So not a lot of detail here, but certainly someone using the same uniform and equipment for the job as the regular employees is something that militates in favor of finding them to be an employee. Now, again, you could have a staffing arrangement such that if there is a misclassification, that is going to be the responsibility of the staffing company or even a PEO. But that's really not what we're trying to cover here. But that's what I would say about that. I know we're on a deadline here, but someone said under the IRS 20-factor test, do all of the items need to be yes or no? No. No, they're not. It doesn't require yeses or nos to each of the questions. Although it's difficult to try to address each of them. They take them on a case-by-case basis. The more you have militating one more way or the other is going to that's how it's going to come out. In Michigan, if the independent contractor is set up as an LLC, does that negate the need to use the independent contractor exemption form? I don't think so. That's a comp question. Are independent contractors required to get workers' comp insurance? that is something that the independent contractor will want to look into with their carrier. And determine if they have their own people, whether or not they should get coverage. Do you have any more here?
I'm trying to see if we've missed any.
Yeah, I know it's a load, but if you look at when we talked about the best practices, I think again that is the best you can do from a sort of overall or more generic standpoint to hedge against the risk of having someone being misclassified. Some of the other examples, though, are bright lines, and depending on the nature of your business, maybe you can achieve greater clarity because your business allows for, a more bright line demarcation as someone being either an independent contractor or employee. It varies based on the nature and the type of business.
Just hitting on the most recent one that came through, that was just if an employee wants to move to Puerto Rico and work remotely, what's the best way to make them an independent contractor? If their job is changed in no other way other than they work remotely and they've moved, I would urge caution in that instance. Again, it's not so much as there's no magic secret sauce to making someone an independent contractor. And while we've provided some best practices, it really goes to the facts that go between the relationship from the employer to the worker. So just by the fact that they've moved and work remote probably isn't enough to change their status.
Yeah, and I mean, an independent contractor for comp purposes with no employees is not required to get comp insurance. But if I'm hiring independent contractors as a company in the state of Michigan, I'm requiring that they make it perfectly clear that they work alone, and if they don't, they have to have their own comp coverage. All right.
I think we're running out of time.
Yep. You know what? I know that this was a load, everyone. I can empathize. We deal with it on a regular basis, but again, when we do deal with it on a regular basis, we have an opportunity to get to know the businesses that we're talking about, and we can better guide how to avoid problems in these areas. It's a tough topic to sort of address generically, and I think Amanda did a terrific job. Thank you, Amanda, as well as the chamber. The chamber is amazing and awesome. Wendy and Becky, thank you.